common types of labor employment claims range anywhere from overtime issues, wage and hour, anything to do with FMLA, to wrongful termination. In fact, statistics show that the 3 most emotionally charged events in a person's life is death of a relative or a friend, divorce, and getting fired. And what are those events even more traumatic? When you're unexpected. And that is the risk that employers face. A lack of proper communication among your managers, your supervisors, and your employees to navigate and address the stickier issues that come up in that employer-employee relationship. What do I mean by stickier issues? Well, how many times have you come across an employee that is out of PTO but needs to go to the doctor and doesn't show up to work because they went to the doctor? Can you fire that employee? Maybe. It depends. That sounds too boyfully. But to give you an example, an employee that is constantly being counseled on absentee issues, PTO issues, coming to work late, is much less likely to turn around and file suit when they're terminated, as opposed to an employee that works for a company that, as Jason and Angelo pointed out, didn't involve a labor and employment lawyer on the front end. That's penny wise, pound foolish, because in the end, you're exposing yourself to, of course, once we are in litigation, our job is to mitigate risk right away. But at the outset, employers can work both with HR and employment counsel to make sure that they're tailoring their company policies to protect against employees who claim harassment, discrimination, retaliation. So it's important that employers recognize that business disputes, employment business disputes, are unique and essentially significantly reduce your risk and financial exposure to employment litigation. So we're talking about discrimination or harassment claims. You're thinking about Title VII, Florida Civil Rights claims. So race discrimination, sex and orientation discrimination. In fact, it's election year, so the feds have been very busy, and for the first time since 1999, the Equal Employment Opportunity Commission has updated their guidelines as to what constitutes sex harassment, workplace harassment, bullying. And it broadened the scope. I mean, this is since 1999, it includes sexual orientation. There's not just race discrimination anymore. The color of your skin is a claim. If somebody's a lighter color than a darker color, and there's discrimination among that. So it's really important that employers recognize that they have to be able to issue spot these potential risks through policies, like you said, Alex, your handbook. Your handbook's a good place to start. Make sure you have an elaborate anti-discrimination policy. Make sure that your employees know who they can go to report what they perceive to be discrimination. A lot of the times, in the cases we receive, our supervisors and managers tell us, oh yeah, he made some creepy jokes, but that's fine. We just brushed it off. It didn't bother me. You don't know who you're working with. You don't know what they take personally. So that's a really big aspect, is making sure that people can report up the chain, so that when a federal investigator comes knocking from a complaint, you can point and say, these are our policies. We've put them in place, and we make sure that we enforce them.